content. In this unit, we I will discuss about powers of Indian Parliament, functions of Rajya Sabha, functions of Lok Sabha, powers and functions of the President. Comparison of powers of Indian President with the United States. Powers and functions of Vice President. Powers and functions of the Prime Minister. Judiciary. The independence of the Supreme Court. Appointment of judges. Judicial review. Public interest litigation. Judicial judicial activism. Lokpal. Lok Ayukt. The Lokpal and Lok Ayukt Act 2013. Functions of High Court and subordinate courts. State executives. Powers and functions of the governor. Powers and functions of the chief minister. Functions of state cabinet. Functions of state legislature. Indian Parliament. India is a democratic republic with a parliamentary form of government. The government at the central level is called union government, and at the state level it is known as state government. The union government has three organs: the executive, the legislature, and the judiciary. The president, the prime minister, and his council of ministers collectively constitute the union executive. Powers of Indian Parliament. Parliament is the supreme legislative body of India. The Indian Parliament comprises of the President and the two houses, Rajya Sabha, Council of States, and Lok Sabha, House of the People. The President has the power to summon and prorog prorog either House of Parliament or to dissolve Lok Sabha. The Constitution of India came into force on January 26, 1950. The first general elections under the new constitution were held during the year 1951 to 1952, and the first elected parliament came into existence in April 1952. Powers of Indian Parliament. All the legislative powers of the federal government are vested in the parliament. The laws framed by the Indian Parliament are enforced in the whole of the country. The Parliament of India is a bicameral legislature. It consists of two houses, Rajya Sabha and Lok Sabha. Rajya Sabha is the upper chamber of the parliament, while Lok Sabha is the lower chamber of the parliament. Powers of Indian Parliament. The powers and functions can be classified into the following categories: legislature powers and functions. The primary functions of Parliament is lawmaking. Lok Sabha plays an important part here. It can pass bills concerning the Union and concurrent list. No bill can be made into law unless it has been passed by Lok Sabha. Second, executive powers and functions. Executive powers are needed in the process of implementing acts and policies in Parliament. The Parliament can remove the Cabinet out of power. The Parliament appoints a committee on ministerial assurance who checks the promises made by the ministers to the Parliament are fulfilled or not. Third, financial powers and functions. Parliament enjoys supreme authority in financial matters. It includes enactment of the budget, examining the performance of government concerning financial spending through financial committees, judicial powers and functions. It includes impeachment of the president for violation of the constitution, removal of judges of the Supreme and High Court, removal of vice president and punish its members or outsiders for breach of privileges. Electoral powers and functions. All parliament members participate in the election of president and vice president. The member of Lok Sabha elects its speaker and deputy speaker from among its members. The Rajya Sabha elects its deputy chairman. 6. Constituent powers and functions. Parliament is empowered to initiate a proposal for the amendment of the Constitution. A bill for the amendment initiated in either House of Parliament. Powers of Rajya Sabha. Powers of Rajya Sabha are legislative power, financial power, executive power, amendment power, electoral power, judicial power, miscellaneous power. Legislative powers. In the sphere of ordinary lawmaking, the Rajya Sabha enjoys equal powers with the Lok Sabha. An ordinary bill can be introduced in the Rajya Sabha and it cannot become a law unless passed by it. In case of a deadlock between the two houses of parliament over an ordinary bill and if it remains unresolved for 6 months, the President can convene a joint sitting of the two houses for resolving the deadlock. Second, financial powers. In the financial sphere, the Rajya Sabha is a weak house. A money bill cannot be introduced in the Rajya Sabha. It can be initiated only in the Lok Sabha. A money bill passed by the Lok Sabha comes before the Rajya Sabha for its consideration. However, if within a period of 14 days the Rajya Sabha fails to pass the bill is taken to have been passed by the Parliament irrespective of the fact whether the Rajya Sabha has passed it or not. Executive powers. The Union Council of Ministers is collectively responsible before the Lok Sabha and not the Rajya Sabha. Lok Sabha alone can cause the fall of the Council of Ministers by passing a vote of no confidence. Amendment powers. Rajya Sabha and Lok Sabha can together amend the constitution by passing an amendment bill with 2 by 3 majority in each house. Powers and functions of Rajya Sabha. Electoral powers. The Rajya Sabha has some electoral powers. Also, the elected members of the Rajya Sabha, along with the elected members of the Lok Sabha and all the state legislative assemblies, together elect the President of India. The members of the Rajya Sabha, Lok Sabha together elect the Vice President of India. Members of the Rajya Sabha also elect a deputy chairman from amongst themselves. Judicial powers. The Rajya Sabha acting along with the Lok Sabha can impeach the President on charges of violation of the Constitution. The Rajya Sabha can also pass a special address for causing the removal of a judge of the Supreme Court or of any High Court. The charges against the Vice President can be leveled only in the Rajya Sabha. The Rajya Sabha can pass a resolution for the removal of some high officers like the Attorney General of India, Compet- Comptroller and Auditor General and Chief Election Commissioner. Powers and functions of Rajya Sabha. Miscellaneous powers. Approval of the ordinance issued by the President. Ratification of an emergency proclamation. Making any change in the jurisdiction of the Supreme Court and the High Courts and making any change in the qualifications for the membership of the Lok Sabha and the Rajya Sabha. Powers and functions of Lok Sabha. Legislative. The Lok Sabha can pass bills concerning all those subjects which have been included in the Union list and the concurrent list. It can pass bills regarding state subjects also in emergencies or if Rajya Sabha by a resolution passed by majority of its total members and 2 by third of its members present and voting declared a particular state subject of national importance. Control over the executive. In a parliament form of government, the most important functions of a lower house is control over the executive. The lower house of our parliament is not an exception. According to Article 75, third, the Council of Ministers is collectively responsible to the Lok Sabha. This means the ministry must tender resignation if a vote of non-confidence is passed against it by the Lok Sabha. Electoral functions. Article 54 of the Constitution vests electoral functions with the Parliament. The elected members of both the houses of Parliament constitute a part of the Electoral College for the election of President. Article 66 provides for the election of the Vice President by the member of both the houses of Parliament at a joint session. The Lok Sabha elects its speakers as well. Financial power. The Lok Sabha's control over purse is an undisputed fact. A money bill must be initiated in the Lok Sabha. When passed by the Lok Sabha, it is to be transmitted to the Rajya Sabha for its recommendations. The Constitution, however, requires the Rajya Sabha to return it to the Lok Sabha with its recommendation within 14 days from the date of receipt of the bill. Discussion on questions of public importance. The Parliament possesses unlimited power of discussing and debating questions. This is done usually on the occasion of the inaugural and annual address by the President of India. It is empowered to review and criticize the work of the different departments of state during the discussion on the estimates of expenditure, the appropriation and revenue bill. Through such criticism and review, the members of House can get their grievances redressed. Who is President of India? Powers and functions of the President. The Indian President is the head of the state. He is the first citizen of India and is a symbol of solidarity, unity and integrity of the nation. He is a part of Union Executive along with the Vice President, Prime Minister, Council of Ministers and Attorney General of India. How is president elected? There is no direct election for the Indian president. An electoral college elects him. The electoral college responsible for president's election comprises elected members of Lok Sabha and Rajya Sabha legislative assemblies of the states. Legislative councils have no role. Legislative assemblies of the nation territories of Delhi and Puducherry, who does not take part in the president's elections. The following group of people is not involved in electing the President of India: nominated members of Lok Sabha and Rajya Sabha, nominated members of state legislative assemblies, members of legislative councils both elected and nominated in bicameral legislature, nominated members of union territories of Delhi and Puducherry. What is the term of the president's office? Once president is elected, he holds office for 5 years. He sits in the office even after the completion of 5 years, given no new election has taken place or no new president has been elected till then. He can also be re-elected and there is no cap on his re-election. What are the qualifications of the president? A candidate has to meet some qualifications to be elected as the president. Those qualifications of the president are: he should be an Indian citizen, his age should be a minimum of 35 years, he should qualify the conditions to be elected as a member of the Lok Sabha. He should not hold any office of profit under the central government, state government, or any public authority. Executive powers of President. For every executive action that the Indian government takes is to be taken in his name. He may or may not make rules to simplify the transaction of business of the central government. He appoints the Attorney General of India and determines his remuneration. Executive powers of President. He appoints the following people: Controller and Auditor General of India (CAG), Chief Election Commissioner and other election commissioners, Chairman and members of the Union Public Service Commission, State Governors, Finance Commissioner, Commission of India, Chairman and members. He seeks administrative information from the Union government. He appoints national commissions of scheduled castes, scheduled tribes, and other backward classes. He appoints inter-state council. He can declare any area as a scheduled area and has powers with respect to the administration of scheduled areas and tribal areas. Legislative powers of President. He summons or prorogues Parliament and dissolves the Lok Sabha. He summons a joint sitting of Lok Sabha and Rajya Sabha in case of deadlock. He addresses the Indian Parliament at the commencement of the first session after every general election. He appoints Speaker, Deputy Speaker of Lok Sabha, and Chairman, Deputy Chairman of Rajya Sabha. He nominates 12 members of the Rajya Sabha. Comparison of powers of Indian President with the United States. Manner of election. US President is more or less directly elected, whereas the Indian President is indirectly elected. The advantage of the directly elected head of the government is the stability of the government. Unlike Indian Prime Minister, American president is not overpowered by the compulsions of coalition politics, head of the state. The US president is both the head of the state and head of the government, whereas the Indian president is only the head of the state. President of the US is the real executive. Indian president, like the British monarch, is only a tutelar head. Term of office. Term of office. American president holds the office for 4 years and he can seek re-election only once, while the Indian president holds the office for 5 years and is eligible for re-election any number of times. Responsibility to legislature. The US president is not part of any legislature and is not responsible to the legislature. In India, the parliament includes the president and the two houses, Lok Sabha and Rajya Sabha. Removal process. Both the American and Indian presidents can only be removed from the office through impeachment. In India, either house can initiate impeachment proceedings against the president and with the concurrence of the other house can impeachment the president. In US, the power to impeach solely lies with the Senate upper house. Dissolving the legislature. The Indian president can dissolve the parliament while the US president does not have such power. Power and function of vice president. Constitutional provisions. The office of the vice president of India is mentioned in part 5 of the Constitution of India under Chapter 1 Executive. Article 63 of the Indian Constitution mentions the post of Vice President. The constitutional articles from 63 to 73 deal with the qualifications, election and removal of the Vice President of India. Constitutional status. The Vice President of India is the second highest constitutional office in the country. President Vice President. Present Vice President Jagdeep Dhankar is the current Vice President of India and the Chairman of the Rajya Sabha. Powers and functions of the Prime Minister. The Prime Minister of India is the head of the government and country. He is appointed by the President of India after the political party wins a general election and nominates a candidate for the post. The leader of that political party is hence appointed as the Prime Minister of India or the Prime Minister. Prime Minister of India performs his functions by taking responsibilities listed below. The leader of country. The Prime Minister of India is the chief head of the government of India. Portfolio allocation. The Prime Minister has the authority to assign respective portfolios to the ministers, chairman of the cabinet. The Prime Minister is the chairman of the cabinet and conducts the meeting of the cabinet. He can impose his decision if there is a crucial opinion difference and conflict among the members. Official representative of the country. Prime Minister represents the country for high-level international meetings and he is the ambassador of the country. The link between the president and the cabinet. The prime minister acts as the link and bond between the president and cabinet. He communicates and transmits all decisions of the cabinet to the president, which is related to the administration of the affairs of the union and proposals for leg head. The Prime Minister is the head of many organizations and power and programs like Nuclear Command Authority, Niti Aayog, Appointments Committee of the Cabinet, Department of Atomic Energy, Department of Space and Ministry of Personal, Public Grievances and Pensions. Chief Advisor. He also plays the role of Chief Advisor to the President. Functions of Prime Minister related to the Council of Ministers. The Prime Minister recommends the names of members of his team to appoint as a minister. The President can only make those people as ministers whose names are recommended by the Prime Minister. Prime Minister determines which department will be given to which minister and he can also change the allotted department of any minister. He also presides over the meeting of the Council of Ministers and can change the decisions according to his wishes. He can ask any minister to resign or advise the president to dismiss him in case of differences of opinion. Judiciary. The judiciary is that branch of the government that interprets the law, settles disputes, and administers justice to all citizens. The Indian judiciary administers a common law system of legal jurisdiction in which customs, precedent, and legislation all codify the law of the land. The Indian judiciary is considered the watchdog of democracy and also the guardian of the constitution. For Indian democracy to function effectively, it is imperative, imperative to have an impartial and independent judiciary. Functions of judiciary in India. Following are the functions of judiciary in India. The judiciary in India provides justice to the people. The judiciary in India interprets and applies the laws. The judiciary in India plays a role in making laws. The judiciary in India protects rights of the citizens. The judiciary in India is the guardian of the Constitution of India. The judiciary in India also plays a federal role. The judiciary in India is responsible for efficient management of the judicial administration. The judiciary in India has advisory functions. Independence of Supreme Court. The Supreme Court is a federal court, the highest court of appeal, the guarantor of the fundamental rights of the citizens and guardian uh, of the Constitution. Therefore, its independence becomes very essential for the effective discharge of the duties assigned to it. It should be free from the encroachment, pressures, and interferences of the Executive Council of Ministers and the Legislature Parliament. It should be allowed to do justice without fear or favor. The Constitution has made the following provisions to safeguard and ensure the independent and impartial functioning of the Supreme Court, mode of appointment, security of tenure, fixed service conditions, expenses charged on the consolidated fund, conduct of judges cannot be discussed, ban on practice after retirement, power to punish for its contempt, freedom to appoint its staff, Appointment of judges. Appointment of judges in the district courts. Qualification. Article 233 of the Indian Constitution deals with the appointment of district judges. Following are the qualifications for a person to be appointed as a district judge. The person has to be in practice as an advocate or preacher for 7 years or more. The person should not be in working in any other services of the union or the state. The person has to be recommended by the High Court for employment. Procedure for appointment. According to Article 233, the appointment can be done only after consulting the governor of the state and also the judges of the High Court that is exercising jurisdiction in the state. Article 235 of the Indian Constitution provides powers to the High Court to have control over the persons in the judicial service in the district court and other subordinate courts. Appointment of judges. Appointment of judges in the High Court. Qualifications. The qualifications regarding the appointment of a person as a judge in the High Courts are provided in Article 217. According to the article, the person appointed must be a citizen of India. The person appointed should have held a judicial office in the territory of India for at least 10 years. The person appointed should have been an advocate in the High Court for at least 10 years. Procedure for appointment. According to Article 217 of the Indian Constitution, the judges of the High Court can be appointed only by the warrant of the President and his seal. The appointment can be done only after consulting the Chief Justice of India and he and the Governor of the state. The appointment of judges other than the Chief Justice can be done after consulting the Chief Justice of the High Court. Appointment of judges in the Supreme Court. Qualification. The qualification regarding the appointment of a person as a judge in the Supreme Court are provided in Article 124. The person who satisfies all these necessary qualifications is only recommended. They are the recommended person must be a citizen of India. They should not be above 65 years of age. They must have been a judge of one or more high courts continuously for 5 years. They must have been an advocate in the High Court for at least 10 years. The recommended person must be a distinguished jurist in the opinion of the President. Procedure for appointment. Article 124 of the Indian Constitution deals with the appointment of Chief Justice and judges of the Supreme Court. The collegium system is still followed for the appointment of the judges. Article 124 of the Constitution says only 7 judges can be appointed in the Supreme Court and the appointment can be increased when the Parliament deems it to be necessary. The President has the power to appoint judges after consulting the Chief Justice of India, the other judges of the Supreme Court and also in certain cases other judges of the High Court. Powers and functions of the High Court. Appellate jurisdiction. In civil cases, an appeal can be made to the High Court against a district court's decision. In criminal cases, it extends to cases decided by sessions and additional sessions judges. The jurisdiction of the High Court extends to all cases under the state or federal laws. In constitutional cases, if the High Court certifies that a case involves a substantial question of law, as a court of record. High courts are also courts of record like the Supreme Court. The records of the judgments of the High Courts can be used by subordinate courts for deciding cases. All high courts have the power to punish all cases of contempt by any person or institution. Administrative powers. It superintends and controls all the subordinate courts. It can ask for detail of proceedings from subordinate courts. It issues rules regarding the working of the subordinate courts. It can transfer any case from the from one court to another and can also transfer the case to itself and decide the same. It can inquire into the records or other connected documents of any subordinate court. It can appoint its administration staff and determine their salaries and allowance and conditions of service. Power of judicial review. High courts have the power of judicial review. They have the power to declare any law or ordinance unconstitutional if it is found to be against the Indian Constitution. Power of certification. A high court alone can certify the cases fit for appeal before the Supreme Court. Subordinate courts. In the judicial organization of every state, the High Court is the apex body. Below the High Court, there are other courts which constitute the subordinate judiciary. The provisions related to subordinate courts are provided in the sixth part of the Indian Constitution, Article 233 to 237 deal with the subordinate courts. These subordinate courts are of two types, namely civil and criminal. Judicial review. Judicial review can be understood as a form of court proceeding, usually in the administrative court where the lawfulness of a decision or action is reviewed by the judge. Where there is no effective means of challenge, judicial review is available. The concern behind judicial review is that whether the law has been correctly applied with and right procedures have been followed. Judicial review plays an important role as a protector when the executive, judiciary, and legislature harm the constitutional values and deny the rights. In India, there is parliamentary form of democracy where every section of people is involved in decision making and policy making process. It is true that the primary duty of the court is to apply rule of law and is the groundwork of social equality. By exercising due powers of parliament, rule of law which is to be applied by the court cannot be modified. All those here who are doing public duty are accountable. They have to work within the democratic provisions of the Constitution of India. The concept of separation of power and rule of law is judicial review. Public interest litigation. Public interest litigation (PIL) means litigation filed in a court of law for the protection of public interest such as pollution, terrorism, road safety, constructional hazards, etc. Any matter where the interest of people at large is affected can be redressed by, by filing a public interest litigation in a court of law. Public interest litigation is not defined in any statute or in any act. It has been interpreted by judges to consider the intent of public at large. Public interest litigation is the power given to the public by courts through judicial activism. However, the person filing the petition must prove that the petition is being filed for a public interest and not just as a frivolous litigation. Some of the matters which are entertained under PIL are bounded level matters, labor matters, neglected children, non-payment of minimum wages to workers and exploitation of casual workers, atrocities on women, environmental pollution and disturbance of ecological balance. Any citizen can file a public case by filing a petition in the Supreme Court under Article 32, in the High Courts under Article 226. However, the court must be satisfied that the writ petition fulfills some basic needs for PIL, as the latter is addressed by the aggrieved person, public spirited individual, and a social action group for the enforcement of legal or constitutional rights to any person who are not able to approach the court for redress. A public interest litigation can be filed against a state or central government, municipal authorities. Judicial activism. Active role of the judiciary in upholding the rights of citizens and preserving the constitutional and legal system of the country is known as judicial activism. Public interest litigation (PIL) made judicial activism possible in India. Judicial activism is seen as a success in liberalizing access to justice and giving relief to disadvantaged groups. The active role of the Indian judiciary, particularly that of the Supreme Court, has been appreciated both within and outside India. Judicial activism methods. There are various methods of judicial activism which are followed in India. They are judicial review, public interest litigation, constitutional interpretation, excess of international statute for ensuring constitutional rights, supervisory power of the higher courts on the lower courts. Lokpal. Lokpal is an anti-corruption body or ombudsman responsible for looking into corruption complaints at the national level. It is a statutory body without any constitutional status. Structure of Lokpal. Lokpal is a multi-member body that consists of one chairperson and a maximum of 8 members. Out of the maximum 8 members, half will be judicial members and minimum 50% of the members will be from scheduled caste, scheduled tribes, other backward class, minorities and women. Chairperson of the Lokpal should be either the former Chief Justice of India or the former judge of Supreme Court or an eminent person with impeccable integrity and outstanding ability, having special knowledge and expertise of minimum 25 years in the matters relating to anti-corruption policy, public administration, vigilance, finance, including insurance and banking, law and management. The judicial member of the Lokpal is either a former judge of the Supreme Court or a former Chief Justice of a High Court. The members are appointed by the President or the recommendation of a selection committee. The non-judicial member should be an eminent person with impeccable integrity and outstanding ability, having special knowledge and expertise of minimum 25 years in the matters relating to anti-corruption policy, public administration, vigilance, finance, including insurance and banking, law and management. The term of office for local chairman and members is 5 years or till the age of 70 years. Jurisdiction of local includes Prime Minister, Ministers, Member of Parliament, groups A, B, C and D officers and officials of central government. Its jurisdiction also includes any person who is or has been in charge, director, manager, secretary of any body, society set up by central act or any other body, financed, controlled by central government and any other person involved in act of evading bribe, giving or bribe taking. The Lokpal Act mandates that all public officials should furnish the assets and liabilities of themselves as well as their respective dependents. Lokpal jurisdiction and powers. Powers of Lokpal. It has the power to superintendence over and to give direction to CBI. The inquiry wing of the Lokpal has been vested with the powers of a civil court. Lokpal has powers of confiscation of assets, proceeds, receipts and benefits arisen or procedure procured by means of corruption in special circumstances. Lokpal has the power to recommend transfer or suspension of public servant connected with allegation of corruption. Lokpal has the power to give directions to prevent the destruction of records during the preliminary inquiry. Lok Ayuk. The Lok Ayuk also Lokayuk is an anti-corruption ombudsman organization in the Indian state. Once appointed, Lokayuk cannot be dismissed nor transferred by the government and can only be removed by passing an impeachment motion by the state assembly. The Lokayuk, along with the Income Tax Department and the Anti-Corruption Bureau, mainly helps people publicize corruption among the politicians and government officials. Role of Lok Ayuk. Lok Ayuk investigates cases of corruption where sustained recommend action. Lokayukt is a great check on corruption. Lokayukt brings about transparency in the system. Lokayukt makes administrative machinery citizen friendly. Lokayukt functions largely depend upon jurisdiction vested in him and facilities provided by provided for taking cognizance of citizens' grievances. The Lokpal and Lok Ayukt Act 2013. The Lokpal and Lok Ayukt Act 2013, commonly known as the Lokpal Act, is an anti-corruption act of Indian Parliament in India, which seeks to provide for establishment of the institution of Lokpal to inquire into allegations of corruption against certain important public functionaries, including the Prime Minister, Cabinet Ministers, members of Parliament, Group A officials of the central government, and for matters connecting them. Salient features of the Lokpal and Lok Act 2013. Lokpal at the center and Lokayukt at the level of the states. A mandate for setting up the institution of Lokayukt to enactment of a law by the state legislature within a period of 365 days from the date of commencement of the act. Lokpal will consist of a chairperson and a maximum of 8 members, of which 50% shall be judicial members. 50% of members of Lokpal shall be from scheduled caste, scheduled tribes, other backward classes, minorities, and women. The selection of chairperson and members of Lokpal shall be through a selection committee consisting of the Prime Minister, the Speaker, Lok Sabha, Leader of Opposition in the Lok Sabha, Chief Justice of India (CJI), or a sitting Supreme Court judge nominated by CJI, eminent jurist to be nominated by the President of India on the basis of recommendations at the first 4 members of the selection committee. The Prime Minister has been brought under the purview of the Lokpal. Lokpal's jurisdiction will cover all categories of public servant, all entities receiving donations from foreign source in the context of the Foreign Contribution Regulation Act (FCRA) has excess of 10 lakh per year are brought under the jurisdiction of Lokpal, provides adequate protection for honest and upright public servants. Lokpal will have power of superintendence and direction over any investigate agency, including CBI, for cases referred to them by Lokpal. A high-powered committee chaired by the Prime Minister will recommend selection of the Director (CBI), Directorate of Prosecution, headed by a Director of Prosecution under the overall control of Director (CBI). The Director of Prosecution (CBI) will be appointed by the central government on the recommendation of the Central Vigilance Commission (CVC) for a period of not less than 2 years. State Executive. The State Executive consists of the Chief Minister, the Council of Ministers, and the Governor. It has the same parliamentary pattern as followed by the Union government, with the upper hand being given to the Union in certain matters. This has been done to maintain the unitary spirit of the structure of the country. The Governor plays the twofold role of being the constitutional head at the state level as well as being a link between the state government and the center. He or she acts as acts on the advice of the Council of Ministers and all executive actions are taken in his name. Powers and functions of the governor. The state executive consists of the chief minister, the council of ministers, and the governor. It has the same parliamentary pattern as followed by the union government, with the power with the upper hand being given to the union in certain matters. This has been done to maintain the unitary spirit of the structure of the country. The governor plays the twofold role of being the constitutional head at the state level as well as being a link between the state government and the center. He or she acts on the advice of the Council of Ministers and all executive actions are taken in his name. Executive powers of the government. Every executive action that the state government takes is to be taken in his name. How an order that has been taken up his name is to be authenticated. The rules for the same can be specified by the governor. He may or may not take rules to simplify the transaction of the business of the state government. Chief ministers and other ministers of the state are appointed by him. Legislative powers of the governor. It's in his power to prorogue the state legislature and dissolve the state legislative assemblies. He addresses the state legislature at the first session of every year. If any bill is pending in the state legislature, governor may or may not send a bill to the state legislature concerning the same. If the Speaker of the Legislative Assembly is absent and the same is Deputy Speaker, then Governor appoints a person to preside over the session. He can consult Election Commission for the disqualification of members. Powers and functions of the Chief Minister. In relation to the Council of Ministers, he recommends to the Governor on who to appoint as minister. He designates or reshuffles the portfolios of the ministers. He can ask a minister to resign. Meeting of the Council of Ministers is headed by him. All activities of the ministers are guided and controlled by the chief minister. If he resigns, the entire Council of Ministers collapses. In relation to the governor, all the activities decisions that are taken up by the Council of Ministers are communicated to the Governor by the Chief Minister to report to the Governor information about the administrative affairs if and when asked by the Governor. If any minister has decided on any issue, the same has to be reported to the Governor by the Chief Minister when the same has not been considered by the Council. He gives his advice to the governor for the appointment of the following persons: Advocate General, Chairman of the State Public Service Commission, the State Election Commission, etc. In relation to the state legislature, Chief Minister is the leader of the House and holding this position, he performs the following functions. Before a governor prorogues and summons the sessions of the state legislature, the Chief Minister's advice is a must. Legislative Assembly can be dissolved at any time on his recommendation to the Governor. All government policies are announced by him on the floor of the House. State Legislature. Chapter 3rd of Part 6 of the Indian Constitution deals with the state legislature. Through a uniform pattern of government is prescribed for the states, it is not so in the matter of the composition of the legislature. While the legislature of every state shall consist of the governor and the state legislature, in some of the states the legislature shall consist of two houses, namely the Legislative Assembly and the Legislative Council, while in the rest there shall be only one house, namely the Legislative Assembly. The Constitution provides for the abolition of the second chamber in a stage where it exists, as well as for the creation of such a chamber in a state legislative assembly. The legislative assembly is the popular elected chamber and is the real center of power in a state. The maximum strength of an assembly must not exceed 500 or its minimum strength fall below 60. But some of the states have been followed to have smaller legislative assemblies, that is, Sikkim, Arunachal Pradesh, Goa, etc. Legislative Council. The Legislative Council of a state comprises not more than one third of the total number of members in the Legislative Assembly of the state and in no case less than 40 members. The system of the composition of the council as provided for in the constitution is not final. The final power is given to the parliament of the union. Powers and functions of state legislature. It can create laws on any subject in the state list. It can also create laws on the concurrent list provided the law does not contradict or conflict any law already made by the parliament. The assembly asserts control over the council of ministers. The assembly controls the state finance. The assembly has constituent powers. It elects its speaker as well as deputy speaker. It can also remove them by a no confidence vote. Its participant is the election of India's president. It also considers reports presented by agencies such as the Auditor General, State Public Service Commission, and others. Thank you.